Thank you, sir.
Shri Rajdeep Raiji.
Namaskar. Thank you, Mr. Speaker, sir. At the outset, I would like to thank you for giving me a chance to speak on the Family Courts Amendment Bill 2022, and I stand here to speak in favor of the bill. Mr. Speaker, sir, the Indian judiciary has the largest backlog of pending cases in the whole world, probably. That is not a problem of the system. This is primarily because of the population that we have, and the number of marriages are also exceedingly high, and it's probably the highest in the world. As per the National Judicial Data Grid, NJDG, there are around 4.7 crore cases which are pending before the courts, out of which 4.5 crore cases are in the district courts or the lower courts. High courts have a backlog of around 50 lakhs, and Supreme Court has a backlog of around 72,000. And out of this, 11.75 lakh cases are pending in the family court. Mr. Speaker, sir, the regular courts are basically burdened with civil and criminal matters, and little or no attention is given to the family matters. But things are changing because judicial reforms are being looked into by these governments since 2014. There are pressures from individuals, organizations, NGOs for fast relief of such matters. The 59th report of the Law Commission in 1974 opened up a new paraphernalia. They suggested the establishment of family courts for early disposal and settlement of family matters. Based on the suggestion of Law Commission of 1974, and basically to decongest those trial courts, the Parliament passed the Family Courts Act in 1984, and the edifice of this act was built on two strong pillars. The first pillar being to promote conciliation, and number two is the speedy settlement of the marriages which are basically brought in front of the family court. All these marked a new beginning. The family court started to get established all across the country, and as per the guidelines, a city with more than 1 million population will have one family court, or as per deemed fit by the state government, they can establish family court. So basically, these were the two guidelines. The Act of 1984 laid clear terms in jurisdiction, appointment of judges, and powers and function of these family courts, and these were going on very efficiently in 715 courts established in 26 states of the entire country today. As we look back now, the present amendment of 2022 is necessitated by the case of Omkar Sharmaji versus the state of Himachal Pradesh, which has already been discussed. Now it is important to mention here that the verdict delivered by those courts, especially the Nagaland since 2008 and Himachal Pradesh since 2019, needs to be validated by an act of law which has to be passed from here, and our law minister, Mr. Kiren Rijiju, has rightfully brought this amendment in front of the House. I was hearing with rapt attention one of our learned speaker speaking very nicely, Sri Bhatrahari Mehtabji. I'm an ardent fan of his, parliamentary deliberation. I mostly agree with what he said. 99% of it I agree. But 1% that I have a different opinion is that he said the case is not very innocuous. It has got ramification. It is primarily because we have identified this problem. This is the government which has identified the problem. The first step towards solution is the identification of the problem. So I thank our law minister and our government to identify the issues, the problems or the undoings of the previous government has to be corrected, and this is the reason why this issue has been brought in front of the House. Himachal Pradesh, as rightly discussed, has 3 courts at Shimla, Dharmasala and Mandi, wide notification of 15/2/2019. Nagaland has 2 family courts at Dimapur and Kohima. Basically, this amendment will validate those 2 courts, and the judgment which took place between 2008 in Nagaland and 2019 henceforth in Himachal Pradesh. Mr. Speaker, sir, I have one small answer to make to one of our honorable member who spoke on behalf of a party which is headed by a female, by a very a woman who happened to be the chief minister also. That he spoke of women representation not being looked after by our government. It is just to remind him that we have
माननीय
just
सदस्य, किन्हीं सदस्य के द्वारा रखी हुई बात का उत्तर आप मत दीजिए, केवल आप अपनी बात रखिए।
हाँ,
उत्तर reply will be given only by the honorable minister.
okay,
Please.
So we have just elected a woman to the highest constitutional post of the country, and this government is also credited to be probably in the history of independent India to elect the maximum number of women to the Council of Ministers, which is very, very important, and it is in stark contrast with what happened over the last 70 years. In conclusion, from the perspective of dispute resolution, family courts are a step in the right direction. That is by creating a separate setup infused with differing procedural requirements than those found in the ordinary court system. The thirst for the preservation of family and protection of gender rights is also important and is being looked after. Family is the foundation of our culture and our civilization, and the preservation of this family unit needs to be looked after, and primarily it is also a responsibility of our government. So I end with a wholehearted support to the amendment that has been brought in by the Law Minister. Thank you.
Thank you. श्री हनुमान बेनीवाल जी।
सभापति महोदय, सदन में आज कुटुंब न्यायालय विधेयक